Welcome to LexTalks, Legal Topics Simplified, your companion for exploring the fascinating world of law. Today we're diving deep into a topic that's particularly relevant for you, our law students in India: the powers of the governor in the Indian Constitution.
It's like trying to understand the rule book for this incredible complex game.
Exactly.
We'll be your guides, helping you decode the rules and strategies,
Yeah.
especially those tricky discretionary powers that can really shake things up.
Exactly. We've got a stack of articles and legal texts we've got a scholarly article dissecting the governor's position to a legal blog analyzing recent controversies,
Right.
all to help us understand this balancing act between state and central power.
What's fascinating is how these powers, written decades ago, still shape the political landscape today.
Yeah.
It's like this legal time capsule that bursts open with real-world consequences every time there's a hung assembly or a constitutional crisis.
Okay, let's jump right into a scenario. Imagine a state election leads to a hung assembly. No single party has a clear majority. Now, the governor has to decide who gets to form the government.
Right.
Talk about pressure.
Yeah.
This takes us to the very first puzzle. How does someone even become a governor?
Well, unlike many political figures in India, governors are not elected. They are appointed by the president, as Article 155 of the Constitution states. Our sources suggest that the framers of the Constitution opted for this system to ensure the governor's neutrality.
Right.
Kind of like a referee in a heated match between political parties.
But wouldn't a directly elected governor have more legitimacy representing the will of the people?
It's a compelling argument.
Yeah.
Some legal scholars believe that a governor elected by the people might be more responsive to their needs. However, this could also create friction with the elected chief minister, leading to potential power struggles.
Oh.
The appointed system, on the other hand, aims to prevent that friction.
And it's fascinating to learn from this scholarly article that the draft constitution actually considered direct elections for governors, but ultimately rejected the idea. It really highlights the complex considerations the framers were grappling with. Now, if I wanted to be a governor, hypothetically, of course, what would I need?
Well, luckily, the qualifications aren't too daunting.
Okay.
You'd need to be an Indian citizen and at least 35 years old.
Okay.
That's pretty much it, according to Article 157.
Okay.
Compared to the qualifications for other high offices, these seem almost minimal.
So, experience in public administration or law isn't a requirement.
It seems the framers prioritized maturity and a certain level of life experience, allowing individuals from diverse backgrounds to potentially serve as governors. Now, let's say you become governor. You get a 5-year term, as mentioned in Article 156. But there's a catch.
Okay.
Remember, you hold office during the pleasure of the president.
Now, that's a phrase that always makes me curious. What does pleasure of the president actually mean?
Essentially, it gives the president the power to remove a governor before their term ends without needing to provide specific reasons. This provision has generated quite a bit of debate, as you can imagine.
So the governor isn't entirely independent of the central government, despite being appointed to represent the state.
Right.
It's a delicate dance, for sure.
It is. And this dynamic raises questions about the balance of power between the central government and the states. And speaking of balance, let's not forget another crucial detail.
Okay.
A governor can't hold any other office for profit, according to Article 150.
You double dipping.
Right.
It makes sense, though. You wouldn't want a governor's financial interests influencing their decisions. But hey, at least there's some perks to the job, right?
Oh, absolutely. Article 158 also mentions those enticing perks.
Okay.
Official residences, emoluments, and privileges set by Parliament.
Wow.
But let's not get distracted by the glamorous side of the job. The real meat of the matter lies in the powers the governor wields.
You're right. Let's get to the heart of it. What can a governor actually do?
Think of the governor as the head of the state's executive branch, as stated in Article 154.
Okay.
They have a significant role in shaping the state government, particularly in appointing key figures.
Like appointing the chief minister, right? But they can't just pick anyone, can they?
Exactly. Article 164 clarifies that the governor must appoint a chief minister who enjoys majority support in the state assembly.
Okay.
This ensures that the democratic will of the people, reflected through their elected representatives, is respected. The governor also appoints the Council of Ministers, but again, this is done on the advice of the chief minister.
So it's a partnership, then, with the chief minister wielding significant influence in shaping the executive branch. But it's not always smooth sailing, is it?
You're sharp.
Key.
This is where things get really interesting. Article 164 also throws in a curveball.
Uh-oh.
The Council of Ministers hold office during the pleasure of the governor? This little phrase has fueled numerous legal and political battles.
So there's potential for conflict, especially if the governor and the chief minister belong to different political parties.
This provision has been at the center of numerous controversies, particularly regarding the governor's power to dismiss a ministry.
Okay.
But it's not just about the Council of Ministers. The governor also appoints other key officials like the Advocate General and members of the State Public Service Commission. They even appoint the State Election Commissioner, though the president handles their removal.
There's definitely a layer of complexity there, with checks and balances interwoven throughout the appointment process. It's fascinating how the Constitution tries to prevent any one entity from having absolute power. But what about the governor's role in making laws? Do they have a say in the legislative process?
Absolutely. The governor has the power to summon and dissolve the state legislature according to Article 174. They can also address the assembly, as Article 175 states. Imagine having the authority to call the legislative shots.
That's quite a bit of influence over the lawmaking process. But isn't the state legislature responsible for passing bills?
They are. But the governor holds a powerful card, the veto power. Article 200 outlines the governor's options. They can give their assent to a bill, withhold it entirely, return it for reconsideration, or even reserve it for the president's consideration.
Wait, so a governor can potentially block a bill that's been passed by the state legislature? That seems like a significant check on the legislative branch.
It is, and you can bet it's led to its fair share of controversy. There have been instances where governors have used their veto power, sparking intense legal and political debates. These decisions often end up in court, highlighting the constant tug-of-war between different branches of government.
It makes me realize that studying these articles isn't just about memorizing dry legal text. It's about understanding how these powers play out in real-life scenarios, shaping the political landscape of our nation.
Exactly. It's like watching a political thriller unfold, but with the Constitution as the script. And speaking of real-life drama, you won't believe what happened in Goa in 2017. Welcome back to LexTalks. Before the break, we were just about to unravel the dramatic events of Goa in 2017, a prime example of how those governors' powers, especially the discretionary ones, play out in the real world.
I'm all ears. Give me all the juicy details. What happened in Goa that had everyone talking?
Picture this. The Goa State Assembly elections resulted in a hung assembly. No clear winner, just a political pressure cooker waiting to explode. The governor had a tough call to make, who to invite to form the government.
That's where those discretionary powers, the ones not explicitly laid out in the Constitution, come into play, right?
You got it. And this is where things got really interesting. The governor decided to invite the BJP, which, despite not winning the most seats, still had a decent number to form the government.
Hold on. They weren't the party with the most seats. I'm guessing that sparked a legal firestorm?
Oh, absolutely. The opposition cried foul, arguing that the governor's decision was biased, favoring the BJP, despite the Congress having a pre-poll alliance that could have given them a majority. It was a classic case of those discretionary powers being questioned and scrutinized.
So it landed in the lap of the Supreme Court?
Exactly. The Supreme Court became the ultimate referee in this political showdown. The big question was, did the governor overstep their bounds, or were they acting within their constitutional powers?
What did the Supreme Court decide?
The court ultimately upheld the governor's decision, saying that they had acted within the scope of their discretionary powers. But, and this is a big BUT, the court also stressed the need for the governor to be fair and impartial when making such crucial decisions. It's like a reminder that even with these vast powers, the governor isn't above the law or the principles of fairness.
That's a relief. It shows that the judiciary plays a crucial role in keeping those powers in check. It's a reminder that as future lawyers, you'll be upholding those very principles of fairness and justice. But Goa wasn't the only state with a political cliffhanger, right? You mentioned Meghalaya, Manipur, and Karnataka.
Each state had its own share of political drama, each highlighting different aspects of the governor's role. In Meghalaya and Manipur, the governors, once again facing hung assemblies, invited the BJP to form the government, even though it wasn't the single largest party. This raised eyebrows and fueled concerns about potential overreach by the central government.
I can see why that would be controversial. It touches upon a sensitive nerve in our federal structure, the balance of power between the state and the center.
And then we have Karnataka in 2018. This one was a real nail-biter. After a super close election, the BJP emerged as the largest party, but still short of a majority. The governor invited them to form the government, which by the book seems fair, but the twist. The Congress and JDS had a post-poll alliance, giving them the numbers for a majority.
Talk about a political stalemate. So what happened next? Did the governor just let the BJP proceed?
Not so fast. The governor, probably sensing the political storm brewing, gave the BJP a deadline to prove their majority on the floor of the House. But as you might expect, this move was challenged in court. The Congress and JDS argued that the governor's decision was unfairly biased towards the BJP.
It sounds like everyone was looking to the courts to be the final arbiter in this power struggle.
The Supreme Court, realizing the urgency and sensitivity of the situation, intervened. They ordered an immediate floor test, a classic way to determine which party actually commands the majority.
That sounds like a fair solution. Let the elected representatives decide. So what was the outcome of this high-stakes floor test?
The BJP, unable to muster the numbers, failed the floor test. They resigned, and the governor had no choice but to invite the Congress-JDS alliance to form the government.
What a turn of events. It shows that the governor, despite having discretionary powers, can't just hand over power without due process. And the courts, acting as guardians of the Constitution, ensure that the will of the people expressed through their elected representatives prevails.
The Karnataka case was a landmark moment. It highlighted the importance of judicial review in safeguarding democracy. It also sparked discussions about the need for clearer guidelines regarding the governor's discretionary powers.
I imagine having clearer rules would minimize the potential for political maneuvering and accusations of bias. It's fascinating how these real-world events force us to examine the Constitution not just as a historical document, but as a living, breathing set of rules that impact our lives.
Absolutely. And as future lawyers, you'll be grappling with these very issues, interpreting those rules and ensuring they're applied fairly. But let's shift gears for a moment. We've talked a lot about the governor's role in the executive and legislative branches. What about their involvement in the state's finances?
Now, yes, the power of the purse. I imagine that's a pretty significant area of influence.
You bet it is. According to Article 203, no demand for a grant can be made without the governor's recommendation. They also have the power to authorize expenditures from the state's consolidated fund as laid out in Article 204.
So they're essentially the gatekeeper of the state's treasury, making sure money isn't being spent willy-nilly.
Think of them as the chief financial officer, ensuring responsible and transparent financial management. This power gives them considerable influence over the state's economic affairs.
It's clear that the governor's role extends far beyond ceremonial duties. They have a real impact on how the state functions, from shaping the government to influencing laws and managing finances.
It's a position that demands a deep understanding of the law, a keen sense of political dynamics, and the ability to navigate complex and often contentious situations.
But we haven't even touched upon their judicial powers yet. Tell me, what role does the governor play in the judicial arena?
While more limited compared to their executive and legislative powers, their judicial functions are still quite significant. For instance, they play a role in appointing district judges in consultation with the High Court, as Article 233 states.
So they have a hand in shaping the judiciary at the district level. What else?
One of the most fascinating aspects is their power to grant pardons, reprieves, and commute sentences for offenses against state law, as outlined in Article 161. This is similar to the president's pardoning power at the national level.
It's the power of mercy, the ability to offer a second chance or lessen a harsh sentence. It's a reminder that the law, while striving for justice, also recognizes the need for compassion and flexibility. Are there any limitations to the governor's pardoning power, particularly when compared to the president's?
You bring up a crucial point. While both the president and the governor can pardon and commute sentences, the governor cannot pardon a death sentence. That power rests solely with the president.
That makes sense. It's a recognition of the gravity of a death sentence requiring the highest level of authority.
This distinction highlights the hierarchy within our legal system, where certain powers are reserved for the president. It's also a reminder of the complex interplay between state and central authority that runs throughout our Constitution.
It's amazing how much depth there is to this topic. We've explored the governor's appointment, their qualifications, their role in the executive, legislative, and even judicial branches. We've unpacked those mysterious discretionary powers and seen how they play out in real-world scenarios. But there's still one more crucial aspect we need to unravel the immunities and privileges they enjoy.
Ah, yes. The protective shield that allows them to carry out their duties without undue pressure or fear. But remember, as with everything else, these protections come with caveats. It's like a legal balancing act, ensuring that the governor has the freedom to act while also remaining accountable for their actions.
It sounds like we're about to step into a fascinating and possibly controversial area of discussion. This is where things could get really interesting. Welcome back to LexTalks. We've been on quite a journey exploring the intricate world of the governor's powers in the Indian Constitution.
It's a role that's often misunderstood, seen as largely ceremonial,
Right.
but as we've seen, it's anything but. The governor holds real power, influencing the course of state politics and impacting the lives of millions.
And those powers, especially those discretionary ones, aren't just theoretical concepts. They've played out in dramatic fashion in recent political history, from Goa to Karnataka, shaping the destinies of entire states.
Exactly. And as future lawyers, understanding these nuances will be crucial. It's not just about knowing the articles and provisions, it's about understanding how they're applied in real-world situations, the legal battles they spark, and the impact they have on the balance of power between the state and the central government.
Speaking of battles, we were about to delve into the governor's legal shield, their immunities and privileges. It's a fascinating area because it raises questions about accountability. If they're protected from legal action, does that make them untouchable?
That's the million-dollar question. Article 361 of the Constitution does provide them with immunity from criminal proceedings during their term. It means they can't be prosecuted for any criminal offense while holding the office of governor.
So they have a certain degree of protection while carrying out their duties. It makes sense you wouldn't want a governor constantly worried about legal challenges every time they make a tough decision. But what about civil proceedings? Can someone sue a governor for actions taken in their personal capacity?
It's not a free pass. They're not completely immune to civil proceedings, but Article 361 does provide a safeguard.
Okay.
A civil case can be filed against a governor for personal actions, but only after a 2-month notice is served.
It's a reminder that while the Constitution provides certain protections, it also ensures accountability. The governor can't hide behind their position to evade responsibility for personal wrongdoing.
It's a balancing act, ensuring they can carry out their duties without undue fear, but also preventing them from abusing their power. This area of law is constantly evolving, with court judgments shaping the interpretation of these provisions.
It's a reminder that the law isn't static, it's dynamic, responding to changing circumstances and societal needs. And it's up to us, as legal professionals, to keep pace with these changes and interpret the law in a way that upholds justice and fairness.
Absolutely. This deep dive has been an incredible journey, hasn't it? We've explored the governor's appointment, their qualifications, their multifaceted roles in the executive, legislative, and even judicial branches. We even ventured into those controversial discretionary powers, seeing how they can both stabilize and disrupt the political landscape.
It's been a roller coaster of information, but it's given us a much deeper appreciation for the complexities of the governor's position and how it impacts the functioning of our democracy. So as we wrap up, what are some key takeaways our listeners, especially our aspiring law students, should keep in mind?
I think it's crucial to remember that the governor's powers, while significant, are not absolute. They're bound by the Constitution and subject to the watchful eye of the judiciary.
The Bull-Nye verdict was a landmark moment, demonstrating that even the governor's discretionary powers aren't a blank check. The courts play a vital role in ensuring that these powers are exercised within the framework of the Constitution.
But it's not just about legal checks and balances. Public scrutiny and political accountability are equally important. The governor's actions are constantly under the microscope, from media coverage to debates in the legislature.
It's a reminder that the governor, while appointed by the president, ultimately serves the people of the state. Their decisions have real-world consequences impacting lives and shaping the course of events.
Another key takeaway is the dynamic interplay between the governor and the state government, particularly the chief minister and council of ministers. It's a relationship that can be collaborative, confrontational, or a mix of both.
The appointment of the chief minister, the formation of governments, the potential for a governor to dismiss a ministry, it's a constant dance of power negotiation and sometimes even outright conflict.
Understanding these nuances is crucial for anyone studying Indian law and aspiring to contribute to the legal and political landscape of our nation. It's not just about memorizing articles, it's about critically analyzing how those articles are interpreted, applied, and challenged in real-world situations.
So to our listeners, I urge you, don't just study the law. Engage with it. Question it, debate it, and analyze its impact on society. And who knows, maybe one day you'll be the one arguing a case before the Supreme Court, shaping the very interpretation of these powers.
That's an inspiring thought. The study of law is a journey of continuous learning and discovery, And as you delve deeper into this field, you'll realize that the Constitution isn't just a document, it's a living, breathing entity, constantly evolving as it interacts with the realities of our political and social landscape.
And with that thought, we come to the end of our deep dive into the world of the governor's powers. We hope you've gained a deeper understanding of this complex and fascinating subject.
It's been a pleasure guiding you through this legal labyrinth. We encourage you to continue exploring, to delve deeper into the case laws, the debates, and the ongoing evolution of this crucial constitutional office.
Thank you for listening to LexTalks. Follow, subscribe, and stay notified to never miss an episode.